Canada has a significant money laundering problem, and corrupted money comes flooding into our economy on account of that. Nowhere is that more evident than in Vancouver. Professional money launderers have a term for it. It's called the Vancouver model. It usually involves a lot of foreign corrupt money, and it is distorting our economy. Now, we learned a lot about money laundering in British Columbia recently with the release of the report from retired Judge Austin Cullen, who had been appointed by the provincial government to head up the Commission of Inquiry into Money Laundering in BC. He heard from 199 witnesses, produced a report of 1,800 pages, and he summed up his work succinctly with this statement. This inquiry explored the myriad ways in which the greedy and the devious seek to make their crime-stained money appear legitimate. The Cullen Commission found that between 2008 and 2014, those were the years of his focus, billions of dollars were laundered through BC casinos. The report stated that in 2014 alone, BC casinos accepted nearly $1.2 billion in cash transactions of $10,000 or more, including almost 2,000 individual cash buy-ins of $100,000 or more. And the report noted that that is an average of 5 per day. Now, we are all, at least in British Columbia, we're all familiar with the scenes that we saw on television, clips taken from the security cameras in casinos of people walking in with hockey bags full of money, $20 bills all neatly stacked up for easy counting and managing, and those are used to buy casino chips. The Commission found that these transactions usually happen late at night or early in the morning when law enforcement people weren't paying attention. Judge Cullen put it this way: it would have been apparent to anyone with an awareness of the size and character of these transactions that the lower mainland casinos were accepting vast quantities of proceeds of crime during this period, just to state the obvious. You don't need to be a law enforcement specialist to know that that didn't pass the smell test. And as a matter of fact, a senior investigator with BC's gambling regulator told this to the Commission. He said, in his words, "The cash smells like drug money." But then he went on to note that it simply wasn't the practice of casino operators to make any inquiries with their patrons about the source of cash. We won't ask, you don't tell. Now, I don't want to be too hard on the BC Lottery Commission. They've done a lot of things right, and people have the right to go to casinos and lose money. So I want to make just a couple of important points about things that they did correctly. In February 2015, the Lottery Commission called on the RCMP to investigate a number of people that they suspected of organized crime. And following that investigation, the BC Lotteries Corporation put certain persons, about 600, on a watch list, requiring them to prove source of funds. A couple of years later, they expanded their source of funds procedures based on recommendations from Dr. Peter German, who had been appointed by the provincial government to investigate this. So it's not that the Lottery Commission did nothing. They just did not do enough. And one of their representatives giving evidence at the Cullen Commission put it this way: viewed from the lens of what we now know, everyone could have and should have responded more quickly to those large cash transactions. Now, the BC government has taken this seriously, I'm happy to say. And they've attempted to prosecute at least one bad actor who they felt that they had enough evidence about significant amounts of money laundering activity. The Joint Illegal Gaming Investigation Team conducted the investigation, and they recommended charges to the BC Prosecution Service. But the Crown Counsel, looking at all the evidence, said, well, we don't have enough evidence here to prove that there's not a substantial likelihood of conviction. That's their standard test. So the current Premier, David Eby, who was the Attorney General at the time, and this was his file, he wasn't going to take that laying down, so he tried again. he told his Assistant Deputy Attorney General to retain the services of a special prosecutor to look at it once again, and this time to, if necessary, use the exceptional evidentiary test of a reasonable prospect of conviction, so a much lower standard. So here's a political lesson. If you don't succeed the first time, try it again, but lower the bar. This is a political decision, and I think it was the right one. There was a very real concern in British Columbia that something had to be done in order to stop the erosion of public confidence in our justice system. Now, the result of the independent special prosecutor investigation with the lower bar now, unfortunately, was still a no. In his words, the critical question is whether the Crown would be able to demonstrate beyond a reasonable doubt that this cash was itself the proceeds of crime. He concluded that they would not be able to do that. There's lots of smoke, but he couldn't put his fingers on the fire. So he said, and this is just very recently, he told the provincial government, don't waste your time. Don't waste your money. Don't waste human resources trying to chase this. You will be unsuccessful. Instead, change the law. And he said this, that in his conclusions, that if Canada had laws, anti-money laundering laws, similar to what the UK and Australia has, his opinion might well have been different. And that brings me to the debate of the day, and that is a private member's bill from my colleague, the member for Simcoe North, and I want to thank him for introducing Bill C-289, which would amend the criminal code to make it an offense to knowingly make a false or misleading statement or to provide false and misleading information to a person or entity listed in Section 5 of the Proceeds of Crime and Terrorist Financing Act. False information with respect to verification of individuals. So in other words, don't lie to the bank, don't lie to the credit union, don't lie to other financial institutions, and importantly, don't lie to casinos about whose money you're dealing with. We want to know. There needs to be transparency. That would have made a difference if we had that law to whether or not we would be prosecuting some of these cases of obvious money laundering. It's a very serious crime. If this legislation passes, it would make it an indictable offense with a fine of up to $1 million or jail time of 10 years, or the Crown Council could decide to go by way of summary conviction with a possible fine of $10,000 and 2 years less a day in jail. I'm pleased. People in British Columbia are pleased with this type of legislation because that is exactly what needs to be done. It is a small step, but it is an important step in the right direction. But now more needs to be done. And I'm happy to hear that the Liberal government is again saying that they're going to bring forward legislation for transparency in corporate registries, because we do not, to use the words of Justice Cullen, we do not want the greedy and the devious to hide behind numbered companies as they seek to make their crime-stained money appear legitimate. Mr. Justice Cullen had a few other recommendations from a federal. He had 101 recommendations altogether, but not all of them were federal jurisdiction, but here are a couple that were, which I think this part of it needs to be paying attention to in the near future. It's not for today, but soon. Fighting trade-based money laundering, closer scrutiny of money service businesses, better regulation of the mortgage industry, and procedures for unexplained wealth orders. This is legislation that other countries and jurisdictions around the world have adopted as for their anti-money laundering tools. We should be doing the same. But today, I'm happy to say we are taking a small, important step in the right direction. Thank you.